And now we will hear from Christiane Wendehorst. She's a professor of civil law at the University of Vienna since 2008. Professor Wendehorst is also a founding member and immediate past president of the European Law Institute, chair of the Academic Council of the Austrian Academy of Sciences, co-head of the Department of Innovation and Digitalization in Law, and member of the managing board of the Austrian Jurists Association, as well as the Bioethics Committee at the Austrian Federal Chancellery. She's joining us online.
Thank you so much for the kind introduction. And let me start by saying what an immense honor and privilege it is for me to have been invited for this keynote, which is on trustworthy artificial intelligence, the role of law and regulation. I hope it will be possible to show a couple of slides I have prepared. And let me start by saying how much the mass rollout of AI is going to influence the way we work, the way we live. It's going to affect all aspects of our lives, of our economies, and of our societies. And so all ecosystems, social ecosystems, economic ecosystems, also very traditional ecosystems will, to a large extent, as is shown on the next slide, become AI ecosystems. When we shop online, when we apply for a job, when we enroll at university, when we apply for credit, we are most likely going to be confronted by decisions that have been made also with the help of artificial intelligence. All the businesses around us and public authorities are going to make use of the potentials of artificial intelligence for streamlining their procedures, for making better decisions, and also for making fairer decisions. And AI is going to revolutionize the products and services we see put on the market in Europe. It is not just the pure AI services such as recruitment software or credit scoring software. It's also very traditional products and services such as lawnmowers and toys that are going to be equipped with AI components. And if we could stay with the previous slide for a moment, it is so important with all these players in those AI ecosystems to make sure they can trust in AI. It is important for the providers of AI that they can trust that Europe is the best place for innovation and that they have legal certainty and that they know the products they put on the market and their competitors put on the market are trustworthy. And that holds true even more for the users, the businesses, the public authorities that are using AI for their operations. They need to rely on the fact that they can safely use AI and not endanger their operations and not harm anyone. And of course, it is the really vital interest of all those affected by AI decisions that AI is not going to harm them and is not going to harm our society at large. Now, what is the role of law and regulation in all that? Is it a case for law and regulation to achieve trustworthy AI? Well, yes and no. If you ask lawyers, they will sometimes tell you that law is the panacea for everything, but that is not true. We need a multi-level governance approach to trustworthy artificial intelligence. It is about technology. We need to make sure that R&D efforts go into trustworthy AI and that high ethical standards are already implemented by design and by default. It's also about our society and education. It's about improving digital literacy and awareness for the potentials on the one side, and on the other hand, for the risks and the limits of this technology. And I'm so grateful to John for having mentioned that theory of the artificial mind. That's really what we need and what we need to teach the next generation, but in fact, all generations. It's about the economy. It's about making sure there is a market for trustworthiness, and that the right incentives for creating trustworthy AI and for using trustworthy AI are in place. But then it is also, of course, for law. Law needs to make sure that there is accountability and that effective public and private enforcement mechanisms are in place in order to take rights seriously. So, what did the European Commission do in order to achieve this and to make use of law and regulation? In April this year, it published a landmark proposal for an Artificial Intelligence Act, the AIA, which has already gained worldwide attention and admiration. Needless to say, this Artificial Intelligence Act proposal didn't come overnight. There were years of preparations that went into that proposal, notably by the high-level expert group on artificial intelligence, by various communications of the Commission, by the European Parliament, by all sorts of actors also at national level. And I myself had the great privilege to be co-chair of the German Data Ethics Commission that formulated recommendations for the German government how to cope with AI. And I see with a degree of delight that many of our recommendations have now been taken on board in the AIA proposal. It was not clear. Could we switch to the other slides, please? I'm not as quick as that. Thank you very much. Could we go back? Thank you so much. It was not clear when the AIA proposal was had, what would be the best regulatory approach. Various different possibilities and options were on the table. This could have been a second GDPR with principles, with rules, with procedures, with individual rights, with remedies, including liability. This could have been an ethical principles approach, as suggested by the European Parliament. But what the Commission has, at the end of the day, opted for is a product safety approach. And I believe this is a very good approach because we have to conceive of AI also and primarily as a product, as something that is put on the market by providers and that needs to be safe, full stop. But it is in line with that product safety approach that you do not apply the same set of requirements to each and every AI system. Rather, the proposal rightly takes a risk-based approach. And on the next slide, you see an original Commission slide, which shows very well how the proposal works. And you see that large green bar at the bottom, and that indicates that for the majority of AI systems that pose no or minimal risk, you do not need any specific regulation. You can basically rely on what we have out there at the moment. Then there is that small red area on the top, and that shows that there are certain AI systems that are incompatible with our European values and which should simply be prohibited, including exploitation of group-specific vulnerabilities or social scoring. There is that big layer that orange layer of high-risk systems, those systems where we see increased risks for the individuals, for society at large, like recruitment software, credit scoring software, medical devices, predictive policing. And this is where the proposal imposes a series of very, very strict requirements. And then there is another layer, which is called the transparency risk layer. And that includes bots, it includes deep fakes, emotion recognition systems, where the Commission rather sees a transparency risks. So it is this risk-based approach which is very important and a hallmark, in fact, of this proposal. And when we talk about risk, we have to bear in mind that AI is not like any traditional product. It creates different kinds of risks. It doesn't create just safety risks. It also creates, and John has very well explained that, fundamental rights risks. So we have safety risks and fundamental rights risks, as is shown on the next slide. Because AI as such, AI as a technology, has several dimensions. It has what we call the physical dimension, like we want to have better healthcare, fewer traffic accidents, less emissions, and so on. But it also has a social dimension. We use AI for taking better decisions, for having more fairness, for having more free resources, also for things that matter in life. And those two dimensions come with a downside. They come with risks. We have risks such as risks for death, personal injury, damage of a property, and so on. But we have fundamental rights risks, rights such as, discriminations, a violation of rights such as discrimination, such as manipulation, such as exploitation of vulnerabilities. And those two dimensions have to be taken into account. So the proposal comes with an extended notion of risk. And when we look at the individual provisions, such as on the next slide, we see how they address both types of risks, the safety risks and the fundamental rights risks, as is shown on the next slide. So they are both kind of combined within the AIA proposal, and they are both addressed in the same way. They are addressed, could we please move 2 slides further? Thank you. They're addressed by a range of requirements. So requirements for high-risk AI, such as risk management system, data and data governance, technical documentation, record keeping, transparency and provision of information to users, human oversight, accuracy, robustness, and cybersecurity. I would like to ask the technical team to kindly click forward and also to the next slide and to the next slide. Thank you so much. So this slide now shows us something that is very important for understanding how the proposal works. Because the proposal is not a monolithic block in a desert. It interacts, if you like, and there is a very sophisticated interplay with other legal instruments in the fields. Both legal instruments which are already there, such as the GDPR and consumer protection law and non-discrimination law, and you name it, and law that is still in the pipeline. So if you look, for example, at the prohibited AI practices in Article 5 of the proposal, people have been wondering why, when it comes to biometric identification techniques, the focus is on law enforcement, and why biometric identification techniques used by private players are not addressed separately. And that focus on law enforcement is understandable only when you look at the data protection legislation in place, where you see that the Law Enforcement Directive provides for much more leeway to member states and to law enforcement authorities than does the GDPR for private players that wish to process biometric data. And so you have to understand that interplay between the Artificial Intelligence Act and the GDPR. And it is very important, I believe, to make this clear and also possibly to make it clearer in the text of the regulation itself. People have been wondering why consumer interests are not separately mentioned in Article 5. And the explanation is that this is not to be seen in isolation. Again, let me stress, this is something that comes on top of and interacts with consumer protection regulations, such as the Unfair Commercial Practices Directive out there. People have been wondering, why is there not a separate article on non-discrimination? And the answer is because we have non-discrimination law out there. So we need to see how the Artificial Intelligence Act kind of works together with other pieces of legislation, both existing and in the pipeline. And we must not forget that product safety has to come with product liability. So liability for AI will be the next big task to address. So let me finish by reflecting together with you on where we stand, what we have achieved, and what may still need to be addressed. I think a lot has been achieved with this proposal, and I really congratulate the European Commission. I congratulate Europe for this proposal that it has been put on the table. There are some challenges ahead, no doubt about that. We have to square the circle of creating an innovation-friendly environment and providing the right and a good and a very high level of protection. Now, did we get it right? Did the Commission get it right in all aspects? Maybe, maybe not. Maybe we have to fine-tune some things, for example, concerning emotion recognition systems, but that needs to be discussed. What is also a challenge is to ensure a high level of legal certainty and coherence of the acquis. Is everything now certain and coherent? Maybe we have to fine tune a couple of things. Maybe, you know, the high risk systems that are listed in Annex 3, maybe they're not clear enough. Maybe a couple of formulations need to be fine tuned there. We need to strive for technological neutrality in order to make sure this is future-proof and not just for a couple of years. And that is a challenge. So we need to put in place mechanisms that make sure this can be adapted in a flexible manner to new technology that comes up and to new situations that come up. But let me again close by saying, congratulations on this proposal. It's a huge step forward. And I believe we now have to use like events like this and fora like this to debate what has been put on the table, to move from ambition to action, and to make sure that AI in Europe is used for the best of humanity and humankind. So thank you very much for your attention.
Christiane Wendehorst, thank you for your inputs. It was great to host you here also at the conference. Thank you.